anything that has to do with company, everything, cannot go to state high court. It's federal high court. Any issue that has to do with hire purchase, sale of goods, patent, agency, passing off, copyright, all these things cannot go to state high court, the federal high court. Arms, ammunition, indigenship, naturalization, citizenship, aviation, safety, mining, oil field, all these things. If you have contracted me to mine a particular oil field for you, at the end there's a breach of contract, and you're seeking to enforce an award given against you, in favor of you, you cannot take such application to state high court. Why? Because the Constitution expressly provides that it is a federal high court that has exclusive jurisdiction over the matter. So if you are now asking the court to recognize it, which court will you go? You will go to the court that ordinarily has jurisdiction to hear that matter, because you are representing that court.
Okay.
I don't know whether you're going to say. So outside this, now there's some issues, there's some matters that only FCT court can hear. There's some matter only the state high court, like Ebonyi State here, can hear. That's why we have federal high court in Ebonyi. So that you look at all those things. See, this matter is, the state high court don't have jurisdiction over it. You quickly rush to the federal high court.
Now, for any reason, sorry I cut it short, but for any reason, fine. We now know the cases that should go to the state high court and the ones that should go to the FCT high court, the ones that can also go to federal high court.
Yes.
Now, if I have a case in, does the area of domicile of the contract breach, does it have anything to do with the court you go to? For instance, if it happened in Ebonyi, okay, whether the federal, the state, or the FCT court, and we're having a conflict here in Ebonyi, can I?
And the subject matter is in Port Harcourt.
In Port Harcourt. Sure. Can I just bring it there?
Of course, now.
To any state?
Very well. Sure.
Okay.
Sure.
All right, that's a good one, and that's exactly where we'll be calling it shots for. And now we need to go for a little break, and when we come back, Settle with Laughter continues, and is still the recognition and enforcement of an award. Please stay with us.
The wheel of justice may grind slowly, but it will surely get to its destination of undiluted justice. But while you wait for justice, have you imagined how that long-drawn case can be settled out of court? Yes, we mean rebuilding our culture of amicable settlement of disputes through alternative dispute resolution. Settle with Laughter is a program tailored to educate, inform, sensitize, and promote access to justice through alternative dispute resolution anchored on mediation, consensus building, restorative justice, negotiation, and arbitration. Join an alternative dispute resolution expert, Barrister Ben Odoh, on Settle with Laughter on Soul TV, Abakaliki. Settle Dispute Television is an initiative of Negotiation Powerhouse Company Limited.
Back on Settle with Laughter on Soul Television. We are still onto the recognition and enforcement of an award. And earlier I told you, my name is Chika, and I have with me our regular guest, Barrister Ben Odoh Uruchi. And I want to come back to you, sir. Please, we have looked at what the difference between the recognition and, of course, the enforcement. We've also talked about where this application can be made. Fine, this time around, I want to know what exactly is the procedure for the recognition and enforcement of an award.
Thank you. The procedure for enforcement and recognition of award, there are two procedures for this enforcement and recognition of award. Number one is action at law, and number two is action on the award. Number one is, I said, is action at law. Number two is action on the award. Now, when we talk about action at law, for you to apply for recognition and enforcement of the award, you must go to court to file action through writ of summons. Now, this writ of summons can be ordinarily or specially endorsed writs. Now, Section 31, subsection 1 of the Arbitration and Conciliation Act of 2004 provides that an award shall be deemed to be recognized by the court. And then, upon application in writing to the court by a party subject to Section 31, sub 1 and Section 32, that the court shall recognize the award as binding and be enforced. So, how do you do it? You can just rush to court through action and law by writ of summons and apply to court for the court to do what? To recognize. In fact, the award is deemed to have, for going to court, the court will recognize it. And when you make application, because it must not be application, oral application. For you, for the process is that the application must be in writing. Once it is in writing to the court, and once it is in writing to the court, the duty of the court is to do what? To enforce the award. Now, the process of enforcing this award by any party who wants to go to court for this application is provided for under Section 31, subsection 2. That the party applying to the court for the court to recognize and enforce an award must furnish to the court, 1, that application, which must be in writing, and that application must have an annexure of 1. You must also, in addition to the application, submit before the court, number 1, original copy of the award. That's an attachment to the application. Like I said, it must be by writ of summons. So you must attach original copy of the award or is duly certified copy thereof. That is the CTC, certified true copy. Number 2 is original copy of the arbitration agreement. That's to say, original copy of the deed of contract containing the arbitration agreement or arbitration clause. So if you are applying to the court to ask the court, look, recognize and enforce this award, in the application you must have an attachment, an annexure to the application of 1. The award you are asking the court to recognize and enforce, you must show them the original copy of it. Like I say, you cannot put something on nothing and expect it to stand. You're asking the court, enforce this award. You're asking the court, recognize and enforce this award. What will they enforce if they don't see the original? But so you're expected to attach the original of the award in the application or a photocopy, a certified true copy, duly authenticated copy of the award. 2, you're also expected to attach the deed of contract that led into that relationship, and then attach a copy of that original arbitration agreement or is certified true copy. If you fail to do that, the court will not enforce it. You must attach that. I don't know whether you agree I'm saying that. You must attach that. Now, I give you an example. Sorry. In the case of Ebonyi versus Ebonyi and Sons Trading Company, I think it's a 2001 case, 2001 through Nigerian Weekly Law Report, part 696, 32. You see that.
Excuse me. Hello. Yes. Okay, you can go on, but before we go on, my cherished audience, I just want to tell you that this is the point where the business gets interactive. This is when you can make your calls, making comments, and maybe suggestions or questions, as the case may be. You can also go to our Facebook page and like our Facebook and drop your comment at www.settlewithlaughter.com, or at Instagram, it is Settle with Laughter. On YouTube, it is Settle with Laughter. Twitter handle is Settle with Laughter. I will always tell you that on our Twitter handle, laughter is spelled LAFTA. And if you want to call us straight away, the number is on the screen of your television set. You can call us on 0802-408-3108. In case you also want to send SMS, it is on to 0803-509-7383. Please go ahead with your... Hello. Okay, please go on.
So, I don't know where I stopped.
We are actually looking at the ways you can arrange your application.
Yes, so if you, so I was quoting the case of Ebokan,
yes.
Ebokan versus...
Hello. If you can move away from your TV set, we'll be communicating better. Okay, it's a simple rule that you really want to communicate effectively. Just move away from your television set or turn down the volume on that television set. And that way we communicate better. Hello, good morning.
Good morning.
Good morning. Your name and location, please.
My name is Captain Jata.
Your name is?
Captain Jata.
Captain Jata, where are you calling from?
Abakaliki.
Captain, you're very close to your radio, to your television set, but you can go ahead.
Okay, let me ask you.
Please do.
I want to find out a situation where somebody was awarded
I don't like that. Okay, maybe he's talking about an award. Oh, please, can you call us back, Captain Jata, so we get to find out what you have for us. Hello. Hello, good morning. Hello? All right, go ahead, please. The Equinibe and...
yes, in the case of Ebokan versus Equinibe and Sons Trading Company, is a 2001 case. 2001, to Nigeria Weekly Law Report, part 696, at page 32, particularly ratio 261 to 263. You find out that in that case, in the application, the applicant, in making the application, did not submit original copy of the award. And the court did not grant that order for enforcement. So it's as fatal as that.
Now, wait. That original copy is meant to be my property. If
yes.
I give it to the court, how do I get it back?
No, you are giving it to the court for citing. It will be in the distance, or you give them certified true copy. You keep your photocopy. Then at the end, the court, you can apply to have your documents back. You are not saying, court, I dash you and keep it. The court must see the authenticity of what you are asking for. I don't know whether you agree, so that you will not mislead the court. So you must have that attached to what you are submitting to the court in the application. The second.
Hello. Hello.
Hello.
Yeah. Good morning.
Hello.
Yeah. Hello. Good morning. I can hear you. Please, what is your name and where are you calling from? Okay. Go ahead, please.
Now, the second procedure is action on the award. The first one is action at law. The second one is action on the award. Remember, I told you these things you must submit is very, very important. Even the court have upheld this in the case of what's it called? Bill Construction Company, Emani versus Bill Construction Company. Mm-hmm. So it is very, very important that you submit all this things. The second one is action on the award. Section 31, subsection 3 of the Arbitration and Conciliation Act provide that an application can be made to the court or to the judge for an award to be enforced. Are you what I'm saying?
Yes.
Now, that is to say, on this premise, action on the award is based on this premise. That's to say, you don't even need to start asking the court to come through section 31, subsection 1, subsection 2. All you need to do to go to the court, to tell the court that by entering into arbitration agreement, it is deemed that parties entering into the arbitration agreement have surrendered their right to be governed by the arbitration agreement. and they are expected to carry out the outcome of the arbitration agreement, which is the award. So by this, you don't need anybody to beg you to carry out what the award says. So you're asking the court, look, we have entered into arbitration agreement, and this arbitration agreement is binding, and because of this, the award is a byproduct of the arbitration agreement. Help us enforce it.
Now, but can the court refuse? And that's going to be the last.
No. So on that you can on that note you can go to the court, apply to the court through originating motion, and it will be served by an adverse party. And if you are doing this thing, you are going to come to court, make the application, and come. I have an attachment of an affidavit. In this one, you must have an attachment of affidavits, and then original copy of the award or the certified true copy, then original copy of the arbitration agreement or its certified true copy. Once you have it, the court will listen to you and grant your prayers.
Now, but finally, I'm saying, can the court refuse to recognize an award? And
yes.
Why would they want to?
The court has inherent discretion to either accept to recognize an award or refuse to recognize an award. The law gave, outside this inherent discretion, the law gave grounds for the court to refuse recognition and enforcement of award. The law provides for these grounds under Section 52 of the Arbitration and Conciliation Act. Number one is on the ground of incapacity of the parties. If at the end the court discovers that the parties thereto don't have the capacity in the first place to enter a contract. I am an adult and I entered into a contract with a child, with a minor, and I am asking the court to recognize and enforce that thing. Maybe I entered it under undue influence. I unduly influenced the child to enter. Maybe I'm a lecturer, or maybe like a patient doctor, undue influence. Or you entered into a contract with somebody who is a mad person, who don't have capacity of thinking and everything. Under that, a mad person, you don't have capacity to enter into a contract. For a minor, they don't have capacity to enter into a contract. So on that ground of incapacity of the parties to enter into a contract, the court can refuse recognizing that the award is invalid because one of the parties or either of the parties don't have the capacity to enter into a contract. Number two, on the ground of invalidity of the arbitration agreement. Now, the parties may be capable, but the arbitration agreement may be invalid because maybe one, I deceived you and they entered into arbitration agreement with me, making the arbitration agreement invalid. I can say because you didn't enter that agreement with your whole mind. I don't know whether you agree what I'm saying. Yeah. Or I unduly influenced you, or I misled you, or I hypnotized you to enter into an agreement, arbitration agreement. So on that ground of, number two, on the ground of invalidity of this thing, then they can. Number three is on ground of lack of jurisdiction. If they discover that the arbitral tribunal don't have jurisdiction or exercise jurisdiction, they have excess jurisdiction, they have acted beyond scope of submission. Like the example I gave you, you're asking for 30 million, and the arbitral tribunal gave award for 40 million as against 30 million. Yeah. They have acted beyond scope of submission. On that ground of excess jurisdiction, they can refuse to recognize the award, they can refuse to enforce the award. Now, if the composition of the arbitral tribunal is contrary to the agreement of the parties, the court can refuse that. Maybe the parties have agreed that the composition of the arbitral tribunal shall be 3 or shall be 1, and at the end they had a composition of 5 arbitrators in the arbitral tribunal. The court can say the composition is contrary to the agreement of the parties. So on that ground, they can refuse to recognize the award or refuse to enforce the award. And then finally, on the ground that the arbitration agreement, the arbitration award, is not enforceable pursuant to any applicable law. Are you know what I'm saying? Under the applicable law, the award cannot be enforced. The award is against public policy, public morality, is against the law. Then on that ground, they can refuse to recognize and enforce an award. Maybe I'll give you an example now. You go to Zamfara, and you're asking the person to bring you 20 crates of small stout as to appeal. It's against their law there, alcohol and other things. So it must not be contrary to the applicable law of where it is seek to be enforced.
Okay, there was stuff you mentioned earlier that I actually wanted. You said something about hypnotizing, and I don't want you to take so much time because the time is really pressing out on us. We have less than 2-3 minutes to get out of here. So you said, or that you hypnotized him. If I bring in cases like hypnotizing in the court, will you people allow it? Because there's no proof to that. Is there any?
Oh, if you're saying I entered this, if you're saying I entered this into agreement, and I don't know when I entered, not my agreement, you don't know when I entered it, the court will look at it and then I will not recognize it.
Good. I think it's better like that, but because
you can say I'm hypnotized. You can be under any influence. You can be hypnotized by anything. You can be hypnotized by spirit. If you are able to establish that, then the court will listen to you.
All right, thank you so much. And this is exactly where we'll be calling it quits for today. This is exactly where the curtain will be drawn, and we'll have to go to come back for another day. My name is Chika, which has been Settled with Laughter on Soul Television. And my regular guests, my wonderful friend, Barrister Ben Odoh, also here. Sir, thank you again for being with us today.
Thank you for thanking
We're going to do it next week, Saturday.
Okay.
That's a good one, and I know you will be there until we meet again. Yes, we will all be there. The difference between us today and us that we'll have on Saturday is that we're going to be richer, we're going to be healthier, we're going to be happier. God bless you and stay out of trouble.